Hello, my name is Craig Altman. I am the founder and president of Tradition Software and Tradition Lien Service. These companies are headquartered out of suburban Chicago in Warrenville, Illinois, about 30 miles west of the city. For many years, especially since our inception was in 2005, we were based in and around suburban Sacramento, California. Today, I'm going to talk to you about construction lien law, specifically as it relates to the state of California. California means a lot to me personally. After moving there in 1992 from Chicago, I got married and started a family. We began raising a family in Fremont, California, in the heart of Silicon Valley, and we later moved to Roseville, California, where my kids graduated from high school and are currently residing post-college and post-Marines. My son, the former Marine, is now working as an HVAC technician for a family business in Rockland, California, and my daughter is working as a newly minted certified nurse at the University of California, Davis Medical Center in downtown Sacramento, California. Now, before I go on and talk about construction lien law in California, I do have to give a legal disclaimer, and that is Tradition Software, Tradition Lien Service, myself, Craig Altman, makes absolutely no warrant, express or implied, for the use of our websites, anything that I say in a legal context that we're given legal advice. Tradition Software and Tradition Lien Service and Craig Altman cannot be held liable to anyone for any problem, claim, or loss arising from the use of our websites, our software, pre-lien to lien, our document preparation services, or the contents of this video. Tradition Software, Tradition Lien Service, and myself, we are not engaged in practicing law in the state of California, nor does Tradition Software, Tradition Lien Service, or myself provide legal advice in the state of California. Okay, now let's talk a little bit about construction lien law. Construction lien law in California can be intimidating to somebody who's new to it, but really it comes to a couple of very simple concepts. And those concepts, first and foremost, start out with your role as to whether you are a general contractor in California or whether you're a subcontractor. If you are a subcontractor, meaning you are not in direct contract with the property owner, you're working typically under a general contractor or what might be called a direct contractor. You know, there is a notice called a preliminary notice at the beginning of a project that needs to be done, okay? And as I share my screen here, I'm going to direct you towards the Tradition Software website here, and you can see that as you scroll down towards the bottom, there is a state deadlines menu here, of which if I select California, I have a nice one-page cheat sheet about the state of California and the construction lien process. Now, a preliminary notice is required at the beginning of a project within the first 20 days of providing equipment, labor, material, services for a project that has a value of $400 or more, okay? Now, it can be done after the first 20 days, but for each day that you late, you can potentially lose and could lose 1/20th of your financial interest for what you provided in a project. And by the 40th day, a construction or the owner of a project or the general contractor has every right to actually not pay you at all if you are late in delivering the preliminary notice. Now, a preliminary notice can be produced out of pre-lien to lien, or our lien service, Tradition Lien Service, can also prepare a document for you. And you know what this notice is going to typically look like, especially if it's on private commercial projects in California or residential projects, is something like this. And this is in large part a statutory notice according to laws that were set by the California State Legislature and were revised on July 1st of 2012. And what you see in the preliminary notice here is, first of all, a declaration on item number 7 as to where the project is located. And ideally, you have not only the address for that project, but what's called an APN or assessor's parcel number for that project, because that's really going to be the legal definition according to the county for that project. You're going to declare on that project preliminary notice the mailing address for the property owner, including their name. And the mailing address is not always going to be what somebody tells you. So make sure you do some kind of verification on that. There's going to be a declaration that you need to provide as to who the contractor is for the project, who you are in direct contract with, which can be the same as the direct contractor or general contractor. You're going to declare what you did in terms of labor, materials, or services for the project. You're going to declare your company on the notice, when you first started the notice, the estimated price of what you're providing for that project. And then there's going to be a declaration with signature here as to the delivery of the notice. And this delivery should typically be done by USPS certified mail. It can also be hand delivered to somebody, but you need to make a declaration that you sign to as to how this is done. Okay. And if the notice is on public works property, and that public works property could be Sacramento Airport, it could be Cal State Chico or Cal State Monterey Bay, University of California, the Roseville Public Library, Newark Memorial High School in Newark, California. You cannot put a lien on public property. And so what's really important about public works projects is that you get the name of the surety or the insurance company from the general contractor, and you also get the bond number for that project. And if you're not being paid, you can't put a lien on those public properties, but you can certainly make a claim through the insurance surety. And that is going to be the best way for yourself to get paid, because just like an auto accident, and the fact that you don't want to have your insurance company contacted maybe for a very minor accident, because it's going to raise your policy the next time, or it's going to raise your policy almost immediately. A general contractor is not going to want to have a claim made for non-payment or slow payment on a public works project. Okay. Now, going back to my website here, after the preliminary notice, if you're not paid, you certainly have an option, both as a general contractor and as a subcontractor or subcontractor supplier, to do a lien warning notice if it's on private property. And you can even do a warning notice, which is called a notice of intent for a public works project. And typically with a 10-day warning notice, this can shake the trees to get you paid, or can get you paid, I should say, with about a 25 to 33% success rate when you do a warning notice. And you're going to send it by certified mail, certainly to the owner, and you want to consider sending it by certified mail to the contractor also. Now, what's really important now is on private property, there is a deadline to record a construction lien, which in California is called a mechanics lien. Okay. And a mechanics lien needs to be done within and up to 90 days of the last day of providing equipment, labor, materials, or services on a project. Okay. Now, if you're the first one in on a project, say you're doing site excavation or site improvement work, there's an argument that that 90 days is project completion, and certainly companies are successful in doing that, and there's a very strong argument that that's what the law says. But what I always say is don't delay if possible. Try to do it within 90 days of your last participation, providing either equipment, labor, materials, or services on a project. Okay. Thereafter, then you need to be cognizant of the fact that a lien does not always get you paid. Again, there's a success rate that's less than 50% when a lien is recorded. So you need to hire an attorney or consider hiring an attorney to do what's called a foreclosure lawsuit or a lis pendens lawsuit if you're not paid. Okay. And I'm not an attorney in California, as disclosed earlier, but on our website, we do have a link for construction attorneys that we can recommend, and or, an attorney needs to be hired and start that foreclosure lawsuit within the 90-day period after a lien is recorded. Okay. Now, there's some other situations that can shorten the lien time frame, and that is when a general contractor or owner files a notice of cessation or a notice of completion. And if that's the case, your time frame to record a lien is much shortened. It's 30 days for subcontractors and it's 60 days for general contractors. Okay. Now, all that being said, we would like to help you. We are in suburban Chicago, but we can be reached Monday through Friday from 8 a.m. to 5 p.m. Central Standard Time. And we have an 800 number that we want you to call us at, and that is 800-886-8770. More often than not, you're going to speak with me. And I hope that this video gave you some information about construction lien law, but if you have any further questions, do feel free to call us. And I hope you have a good day. Thank you.